Hi, everyone. We're going to be doing some notes today. I apologize I couldn't be with you, but we will certainly be reviewing this information when we are all back in class together. So, the expectation for today is you should have a guided note sheet in front of you. This is going to be your file number 3 for Unit 2. So, the Unit 2 is the Constitution. So, if you don't have this guided note sheet, please go grab one, or you can ask whoever is in the room to get you one. But please make sure you're taking notes as you are watching this. There are not going to be any questions here on the Ed Puzzle, but you are going to be expected to take the notes kind of as we go through. So please make sure you have that in front of you. So, like I said, we are going to be discussing the U.S. Constitution. I know we've been looking at the outline of the U.S. Constitution, so what all of the different articles entail, what specific branches are basically established in each article of the Constitution. We've looked at the functionality of the preamble, but what we haven't really done is looked at some of the overarching themes. Right? We looked at some inspirational documents like the Magna Carta. We looked at some ideas that were gained from the Petition of Right and the English Bill of Rights. But what actually is in the US Constitution in kind of like broad ideas, major strokes of the discussion of what the founders actually wanted to establish with the US Constitution is what we're going to look at today. So, our big question is, why is power important in a government? Should power be limited in order to create a government for the people? Basically, how do we distribute power in order to create something effective? And that's what we're going to discuss today. So, what a constitution actually is kind of important to discuss. We've previously, as we're talking about the constitutional outline, we've compared it to some IKEA directions. It's basically a skeleton, it's a framework of how government works and operates. It is not the same thing as a law, because laws can more easily be amended or changed. Constitutions usually can be amended in some way, shape, or form. In the United States, we specifically learned from the Articles of Confederation that having a process for amendment that is actually feasible is really important. Otherwise, it negates the integrity of the document. But constitutions are used all around the world to set up about, a basic structure of how governments work and operate, right? What types of different lawmaking structures do they have? Who leads the executive branch? Who enforces the law? Whose job is it to, interpret the law and hold people accountable for breaking the law? So I like to compare it to a skeleton, right? Because a skeleton, as important as it is to the human body, doesn't function on its own, right? It provides the structure, right? It provides the thing that holds the government up and puts everything where it should be. But a skeleton, a human skeleton, will not work without, muscles and ligaments and organs and, a functioning, vascular system, whatever. So there are other things that are necessary to make the skeleton a human being, right? A government. Because governments are not created by constitutions. They are held up by constitutions, but they are not fully functional unless there are other measures in place. So there are about 193 modern nations that have some form of a constitution. They all look vastly different. Some of them have some pretty broad stroke similarities, and we'll discuss some of those as we go on. But according to the United Nations data, there are about almost 200 nations that have constitutions functioning. Whether they follow them, whether they use them, is again a different story. But many nations around the world, have a constitution and use it very similarly to the United States. So this is a bit of a diagram that'll kind of give you an idea of some of the world's oldest constitutions. We can see here on the map that the oldest is actually from the United Kingdom. So think England, Britain and Ireland, etc. So that's the year 1215, and that's actually the Magna Carta, right? It's considered the funding instrument of the constitutional framework of the United Kingdom. So that Magna Carta, the Great Charter, is used essentially as their constitution, even though it's obviously been changed and built upon. But that's the earliest example of constitutional framework. Other nations around the world kind of set up similar constitutions to the United States, and it was kind of a domino effect. You can see that the US has its constitution established and officially ratified in 1789, started in 1787. And then you can see that other nations kind of followed suit, right? Canada in 1867, Australia, we can see Luxembourg, Belgium, the Netherlands, right? All of these other nations kind of followed suit. Argentina, right? A lot of South American countries started to establish independence after the United States. There was a bit of a wave of revolutions that kind of followed. France, right, did a similar thing. So constitutions, like we said, are not uncommon around the world. They are certainly a similarity between a lot of nations' governments, and a lot of them actually were created, in some way because of the U.S. and its success in creating a constitution in the late 1700s. So the Articles of Confederation, like we said, were supposed to be a constitutional framework. If we can remember back, what were two major weaknesses of the Articles that made the founders kind of want to scrap them, start over? You guys can pause here and see if you can kind of guess what two of those major weaknesses were. If you've already guessed, or if you've paused, or if you're not doing that. Some two big weaknesses were, one, that they couldn't be amended, right? It required unanimous consent among the different states in order to amend the articles. And we know that unanimous consent for anything is difficult to get, right? It's hard to get 100% of a group to agree on something. Additionally, they didn't give the government enough power, right? We know they didn't have taxation or any measure of taxation for the national government. There was no founding way to do that. There was no military as a result. There was no judicial system. They couldn't regulate interstate trade. So not giving that central government enough power was certainly an issue that was addressed with the creation of the Constitution in the summer of 1787. So diving into the U.S. Constitution, we know that they're divided into sections called articles. Articles are basically just smaller sections of the U.S. Constitution, right? They're basically chapters, if you will. And these sections all have kind of different purposes. So the preamble is like the introductory paragraph. I like to call it the thesis statement of the U.S. Constitution. It set forth the goals for U.S. government. And we actually already know these goals because there are purposes for government, right? Things like forming a more perfect union, like providing and, for the defense of the United States, to provide for the general welfare, to, ensure the blessings of liberty, right? All of the purposes of government are things we've discussed, and they are all simply statements from the preamble. So the preamble is basically the founding fathers' goals for the U.S. government. Then we jump into Article 1, which is the legislative branch. So the lawmaking function of the United States rests with Congress. Article 2 is the executive branch. So that's the people that enforce the law. So the U.S. president is among that branch, the vice president, and then the various members of the executive department. So think Homeland Security, Defense, the Department of Education, right, Agriculture. All of those executive departments fall within the executive branch. Additionally, we have the judicial branch in Article 3, which sets up the Supreme Court as the highest court in the land, and then establishes that there will be inferior or lower courts, but allows Congress to essentially form them. Articles 4 through 6 are other governmental procedure, right? They have election measures. They have, measures for the creation of and establishment of amendments, etc. And then Article 7 is our last one. It has ratification. So the adoption and approval by the states is the ratification statement. Article 7 is certainly the shortest, but it's possibly the most important because it actually allows the states to ratify or adopt and approve the U.S. Constitution. So the preamble of the U.S. Constitution, we've already kind of alluded to, but let's read it together. And what are some of the goals that you actually hear? You can kind of jot those down as we go. So the preamble to the U.S. Constitution is as follows. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. So what are some of the goals you hear? You can go ahead and jot those down and pause this for a second. So hopefully you got some of those down there. We are going to start looking at the 6 constitutional principles. So the 6 principles of the Constitution are things that the Founding Fathers had specifically in mind when they were creating the Constitution. These were their goals for American government. James Madison is often accredited as the author of the U.S. Constitution, though there were many people that contributed in significant ways, including people such as Thomas Jefferson, such as John Adams, such as George Washington. We can see James Madison on there. You can see all of the different various founding fathers kind of represented here. But James Madison is often accredited as the author of the U.S. Constitution, as Thomas Jefferson is kind of accredited as the author of the Declaration. So things that they wanted and things that they fought over were the strong central government. We know the Federalists and the Anti-Federalists had disagreements as to how strong the central government should be. They wanted to establish measures to protect the rights of the people because the Anti-Federalists feared the strength of a strong central government would eventually allow a figure like a president to become a king. So they wanted to establish things that protected not only the people, but it protected kind of the government from itself. They also wanted to ensure that states had the freedom to operate as they see fit, right? They wanted the Constitution to be what we call a living document, so it could grow and change with our young country. So the first principle that it is important to discuss is called popular sovereignty. So sovereignty, we've discussed a couple different times. Sovereignty essentially is the authority of a nation within its own borders, but popular sovereignty is a little bit different, right? It's the idea that the nation's authority, its sovereignty within its own borders, is popular. It is based on people. So this idea we can accredit back to John Locke, right? The government's authority is based on the will of its people, comes from this idea of kind of social contract. And it also comes from this idea of people having natural rights. And these are both Lockean ideas from the Enlightenment. So John Locke believed that people should give up some freedom in exchange for protection from their government. But popular sovereignty is the idea that the government cannot exist without the people's consent, which we will discuss here. So the consent of the governed is a phenomenon that is also Lockean. Locke believed that if your government violated your rights, you should overthrow it. He believes that the government's only authority basically rests on the fact that the people consent to be governed, right? They agree that the government provides at least more good than bad in most senses. And the government cannot exist without the people's agreement. And I always like to say that the popular sovereignty is a phenomenon not only in US government, but in high school. Think about the fact that you are often alone in a room with one teacher and about 30 high school students. You are kept there, not necessarily by, rules, right? The teacher isn't keeping you in the room. You are keeping yourselves in the room, right? All 30 high school students are staying in the room by popular sovereignty. One, you fear repercussions. If you leave the room, you fear the repercussion of your principal. But also it's this idea that you are all consenting to stay in this room in order to receive something, right? You're getting something out of this exchange. In the specifics of high school, you're getting an education, right? You want a degree in exchange for your essentially presence. So the consent of the governed, right, is kind of described in this little cartoon down here. I think it provides a pretty good idea, right? The government exists on this like diving board, essentially, right? It's hanging precariously over this cliff. And think about what would happen if the people stopped listening, right? If the people standing there with the picket signs stopped listening to the governing figure at the podium, and if they left, like that one person is appearing to do. Would the government continue to exist if people stopped agreeing to follow it? I think you can kind of come up with that answer. So our second principle is separation of powers. And separation of powers we can see pretty expressly in the different articles of the Constitution. The 3 main powers of government should not rest in one person's hands because the founders feared that a king could result from not having enough hands in the government, right? If one person was given too much power, they feared that they could essentially resort to a king. So what they did is they divided the 3 essential functions of government into their own entities, which within them still have separated powers. So they decided that Congress, or the legislative branch, as you can see kind of up here at the top of that diagram, Congress's job is to make the law, right? They are the only ones in government that can make a law. Presidents cannot make a law. The Supreme Court cannot make a law. It only rests in the House of Representatives and the Senate, which within itself still have separated powers. And we'll kind of get back to that in a later day. But the president, their job is not to make the law, but to enforce it, to make sure that laws are followed to some degree, or to make sure that laws are applied to the entirety of the population in some way, shape, or form. The other job within the presidency, as the vice president and then the various executive departments, is also to enforce the law. Lastly, the court's job, the Supreme Court and all the inferiors, their job is to interpret the law, to see if the law has been followed or to see if a law has been broken. That is the job of a judge, right? The job of a prosecutor or a defense lawyer, right? All within that court system. Their job is to interpret and say, hey, has the law been followed or has it been broken, right? Their job is not to enforce the law. It's to determine whether it has been broken, right? Innocence or guilt. So this separation of power ensures that no one branch holds too much power. Right? They all have very separate and defined lanes to stay within. They don't often cross over into each other's lanes. And when they do, there is a separate power that is supposed to kind of step in, and that is checks and balances. So checks and balances essentially prevent each branch from stepping out of its own lane. And if one branch does step out of its lane, it's the job of the other branches to kind of redirect it, if you will. So each branch of government has power over the other to kind of prevent one another from getting too powerful. Because like we said, the framers feared that, one branch could become too powerful if left unchecked, right? Congress has two houses. It's bicameral in order to prevent Congress from becoming too power hungry. The president has a lot of power, right? As the US Constitution, even as it stands, the president is a very powerful figure. And the president, honestly, the framers feared that the most. If left unchecked, the president could become a king if the courts and if the Congress did not step over the president in order to make sure that everyone had, equal authority in the government. So we can see here an example of checks and balances between each branch. The Uncle Sam hat is the president. We can see the white building at the top right. That's the congressional representation. It's the U.S. Capitol building. And then lastly, at the bottom with the book, the scales, and the gavel, that obviously represents our court systems. So we can see here, if we start with Congress, that Congress has the power to impeach, right? They can impeach and remove a president. They can also impeach and remove judges. But the Congress is also responsible for putting the president in power and putting the judges in power in the first place. They have something called confirmation power, which once the president is elected, they have to be confirmed by the Senate, which basically says, yeah, the Senate agrees that the president was, justly elected. And then also the Senate has the power to impeach judges. So basically say, hey, a judicial figure of some sort, a judge, or justice has broken their oath in some way, and they can remove them from their seat. Conversely, the president, as a single figure, has a little bit of power, significant power over Congress, because they can actually do something. If you see the red arrow at the top, they can veto legislation, which basically means to send any bill or law passed by Congress. They can reject it. Right? They can refuse to sign it into law. And they can send it back to Congress. Congress can still pass that legislation. They have to obtain a higher majority. They have to obtain a 66% majority in Congress rather than a simple majority, which is more than 50%. But Congress can still pass that law of the president, which is another check on their power. Another example is that the president has power over the judicial branch because they actually nominate judges. So it's the president's job to put people on the Supreme Court. Congress has power to say yes or no over that, but the president can essentially nominate a judge. They can choose who sits on the Supreme Court as long as Congress agrees. And then lastly, the courts have a significant amount of power. As we kind of argued earlier, I think they have some of the most significant power because they can declare any act unconstitutional. This is called judicial review, and we're going to come back into that in a little bit. So we can see that this checks and balances really goes back to our New Jersey plan. As we said, the New Jersey plan and Virginia plan kind of were the two arguments of the Federalists and Anti-Federalists. And we see that the Virginia plan specifically favored a bicameral legislature, which means a two-house legislature, so the House of Representatives and the Senate. The danger in the unicameral legislature is that Congress would have. So to wrap up with our last couple of principles of the Constitution here, principle number 4 is the idea of limited government. I think this is probably one of the easiest to immediately understand, but also the kind of the hardest to find actual examples of or to understand in practice. But the idea of limited government is exactly what it sounds like. It's that the power of the government should not violate the rights of the people. The government should have limits. And one big example of that those limits, is that governments must have checks on their power in the form of protection for the people in order to limit the power of the government so that the government does not become so powerful that they start to violate the rights of their own people. And the biggest example of this in limited government in the United States is the Bill of Rights. Right? The Bill of Rights places limits on what the government can and cannot do, right? What they can and cannot say, what they can and cannot limit in terms of what the people are allowed to do. So those rights and those freedoms that are guaranteed to the people certainly place limits on the government in terms of what it cannot do. What also limits the government is the Constitution. Right? The Constitution is a self-imposed limit by saying, hey, here's the function of the executive branch. Here's what it is not allowed to do. And it's the job of the courts to enforce that. So these ideas are all from derivative of, again, John Locke. So the principles of the Bill of Rights often kind of come back to this idea of natural rights, right, which is very expressly stated in the English Bill of Rights, which is where a lot of the American Bill of Rights kind of took its influence. So we boil that down to 3 things. We said life, liberty, and the pursuit of happiness is typically what we would say in modern times in the 21st century. But what John Locke actually said is life, liberty, and property. Right? Property meaning the ability to have your own funds and your own businesses and jobs, right? Basically the ability to provide happiness for yourself in terms of, your own property, well-being, your own life. So where we actually see this in U.S. government, right, we see this in a couple of places. One, right, life, liberty, and the pursuit of happiness are expressly stated in the Declaration of Independence, right? We hold these truths to be self-evident that all men are created equal and they are endowed by their Creator with certain unalienable rights. So often we will see these natural rights referred to as the unalienable rights, which basically means that they cannot be taken away. We also see these, like we said, in the Bill of Rights, right? Life, liberty, and property are all things that are protected pretty expressly in the Bill of Rights, whether it's your freedom of speech, whether it's your freedom to petition, whether it's the ability to bear arms, whether it's the ability and right to protect yourself from unreasonable searches, right? The ability to, petition your government to prevent cruel and unusual punishment or, long incarceration. All of these things within the Bill of Rights kind of reflect back on the Lockean idea of the natural rights. So I said we'd get back to judicial review, and here we are. Judicial review is one of the most important constitutional principles because it really endows the court system with its own check and balance to all of the other branches of government, not just, one specific branch. But the judicial review, the principle of judicial review, really boils down to the fact that the Supreme Court may declare any act of Congress and any act of government unconstitutional. So any act of Congress, any act of the president, any function of government, right? Any act of government or governmental, action or inaction really actually may be declared unconstitutional by the court systems. And this is from a court case called Marbury v. Madison. And Marbury v. Madison established the courts may strike down any actions they find unconstitutional. And what Marbury v. Madison really goes back to is this. There was a case in 1803 by a man named William Marbury, who was actually appointed as a justice of the peace by an outgoing president, John Adams, who's the second president, but he did not receive what is called his commission, right? His judicial commission is essentially his salary, right, for all intents and purposes, his job. So the new Secretary of State was James Madison, right? So William Marbury is the judge, James Madison is the new Secretary of State. So the court, which was led by the Chief Justice, John Marshall, ruled that while Marbury did have a right to his commission, the Supreme Court could actually not issue the order to force its delivery, because that law would have essentially granted the court the power was itself unconstitutional. So essentially, the ruling is that the court couldn't enforce Madison delivering that commission because the law that Marbury was using to make his request was actually unconstitutional. So although this is a little bit of a complicated case and it's kind of hard to follow, the significance is because it established that the judiciary was essentially a co-equal branch of government within the executive and the legislative branches, and it gives it the power to be the ultimate, enforcer of any constitutional question. And this leads us to our kind of final principle of government, which we are going to go into more depth at the later part of this unit. But it's called federalism. And one thing I want to do before we get into federalism is actually kind of have you do a little bit of a analysis of a cartoon. So in your notes, it's going to ask you to analyze this cartoon and see how you would describe federalism. If this was the definition given to you for federalism, how would you describe it? So go ahead and take a look at this cartoon, pause here and analyze, and try to write a definition of what the message of this cartoon is. So if you didn't get your definition, essentially constitutional federalism is a system of dividing political power between the national government and the states. So in the cartoon, you saw that there was a balanced scale between the national government and the states. Well, actually, we'll go back here and look at it for a second. And we can see that on this scale, the states actually are a little bit lighter, right? It seems like they're higher than the national government. The national government, if we know how a scale works, right, the lower part of the scale is heavier, right? The national government is much heavier than the states, right? And though they are essentially equally balanced, right, they have their own part of the scale, the national government has much more weight than the states do, right? And this is called the act of supremacy. So we'll go back here for a second. The supremacy clause essentially is that the national government has more power, right? They can tell the states what to do. National laws cannot be broken by the states. Supreme Court rulings cannot be broken by the states. The national government's laws, the states' laws essentially must follow the national government's laws and, executive procedures. But the states do have certain rights. There are certain things that the states are given to control that the national government was not. And these are powers that were not expressly given to the national government in the Constitution. So unless the Constitution specifically said the national government has X power, right? So for example, the national government has the power to control the military, right? That is expressly given, right? The right to declare war was given to Congress. The president was named as the commander-in-chief in the Constitution. So the national government has the right to control the military. However, there are certain things the national government was not given the right to control in the Constitution. One of those things, for example, is the right to control a police force. Police forces are expressly controlled by each state, right? They have to follow the laws of the national government, right? Police officers are required to follow national laws. However, they don't have to essentially be reporting to the national government, right? Pennsylvania's state troopers, Abington Township Police are all controlled by the state of Pennsylvania. Similarly, public education is a thing that is controlled not by the national government, but actually state by state. They have to follow national laws, and there are national policies such as the right of all students to, obtain an equal education, right? That has to be followed by the states. But because public education is not mentioned in the Constitution, the states kind of can figure it out for themselves. So we're going to come back and expressly look at federalism in more depth later in the unit. However, for now, we are going to kind of take a pause on our principles of the Constitution. So hopefully you were able to finish these notes. We are going to be talking about the principles of the Constitution over the next couple of days. We're actually going to be doing a very large project, or fairly large project, on the principles of the U.S. Constitution, on these 6 important principles. So please make sure you save these notes because they are going to be very helpful in doing your project.